We look at the major 2025-26 legal changes affecting the 482 and the 186 visas, how skilled workers can improve their chances, why regional Australia matters more than ever, and what both workers and employers must do to avoid costly mistakes when considering an employer sponsored visa. Good day, everyone, and welcome to our channel. If you're a skilled worker hoping to move to Australia or an employer trying to sponsor overseas talent, 2026 is not business as usual. Employer sponsored visas are now one of the main migration pathways, but the system has become stricter, more selective, and more heavily monitored. In this video, we'll break down what employer sponsorship really means, which visas require an employer, how skilled workers can improve their chances, why regional Australia matters more than ever, major 2025-26 legal changes affecting the 482 and the 186 visas, and what both workers and employers must do to avoid costly mistakes. Let's get into it. So, what does employer sponsorship actually mean? Employer sponsorship is not informal support. It is a legal process where Australian businesses formally nominates a skilled worker for a visa because they cannot fill the role locally. The employer must prove the job is genuine, the salary meets the Australian market rates, and they comply with workplace and migration laws. This process is regulated by the Department of Home Affairs, and once a business sponsors someone, they take on serious legal obligations. Now, let's look at which visas require employer sponsorship. The main employer sponsored visas in 2026 include the Skills in Demand Visa Subclass 482. This is a temporary visa for skilled workers where employers face shortages. Employer Nomination Scheme Subclass 186. This is a permanent residency visa, often through the temporary residence transition pathway or the direct entry stream. Skilled Employer Sponsored Regional Visa Subclass 494. This is for workers sponsored in regional Australia with the pathway to permanent residency. Labor agreements and DAMA. These are special arrangements allowing employers in certain industries or regions to sponsor workers under flexible conditions. Each visa has different rules for skills, work experience, English language, salary levels, and age limits. Not every occupation or employer qualifies under every pathway. If you found this update helpful, don't forget to like this video, subscribe for more migration updates, and hit the bell icon so you never miss a new release. Why employee sponsorship is now so important. Australia has reduced the independent and state nominated migration places under the General Skilled Migration Program. At the same time, employers still face major shortages in healthcare and aged care, construction and trades, engineering, IT and tech, early childhood education. So migration hasn't stopped, it's just become more targeted. Employee sponsored visas are one of the most realistic pathways to both temporary stay and permanent residency. Now let's look at how to make yourself attractive to a sponsor. From an employer's perspective, sponsorship is easy when the worker is visa ready. That means you should already have an Australian standard resume, relevant qualifications and skilled work experience, English test results if required, licensing or registration for regulated jobs, a strong and updated LinkedIn profile. If you already meet visa requirements, the employer faces less risk and less paperwork, and that makes you far more attractive. Now we look at where to find sponsorship jobs. Look out for job advertisements that mention visa sponsorship available, skills in demand eligible, employer sponsored role, DAMA position. You can use Australian job boards, LinkedIn, and connect with recruiters familiar with sponsorship. But here's a big tip: target the right employers. Some employers are much more likely to sponsor than others. Look for businesses that are standard business sponsors, accredited sponsors, already employing overseas workers. These employers understand the process and are more comfortable with sponsorship obligations. Let's look at why regional Australia can boost your chances. Regional areas are experiencing serious workforce shortages. That means employers are often more open to sponsorship. Regional visas like the Subclass 494 can offer clear permanent residency pathways. DAMA agreements may provide concessions on age, English language, or salary. Being flexible about location can dramatically increase your opportunities. We often get asked, can you pay for sponsorship? No, absolutely not. It is illegal in Australia to pay an employer for visa sponsorship. Penalties can include visa cancellation, heavy fines, and employers losing sponsorship rights. If anybody asks you to pay for sponsorship, get professional advice immediately. Now let's look at the migration system in 2026. Australia is not shutting down migration but is filtering more carefully. Due to housing pressure, infrastructure strain, and cost of living concerns, the government is focusing on genuine skill shortages, long term workforce contribution, and proper compliance. Applications that are poorly prepared or marginal are now more likely to be refused. Now let's look at the major changes affecting the 482 to 186 PR pathways. This is critical for current and future 482 visa holders. From the 29th of November 2025, new regulations changed how your work experience counts towards the subclass 186 TRT permanent residency pathway. The key change: to qualify for the 186 TRT pathway, your work experience must now be with an employer who remained an approved sponsor the entire time. If your employer sponsorship expired, was cancelled, was not renewed, that period of employment may no longer count towards permanent residency. What employers must do: employers must now carefully monitor and renew their sponsorship status before it expires. Otherwise, they risk damaging their employees' permanent residency eligibility. Now, let's look at the 482 visa mobility. 482 visa holders now have more flexibility and can move between employers. However, for PR under the 186 TRT pathway, the work must be with an approved sponsor. The nominating employer must be your most recent sponsor. So, changing jobs is possible but must be managed strategically. Now, let's understand the compliance requirements and the cancellation risks. The new rules also expand visa cancellation powers if sponsors breach obligations, confirm that sponsors may have to cover travel costs for workers leaving Australia, clarify review rights if a 482 skills in demand visa is refused offshore. This means both employers and visa holders are now under closer scrutiny than in previous years. Finally, we look at why professional advice matters more in 2026. In a tighter migration environment, small mistakes can have big consequences. Refusals, delays, loss of permanent residency eligibility, sponsors compliance breaches. Professional migration advice helps ensure the correct visa pathway is chosen, employers understand obligations, applications are decision ready, and long term PR strategies are protected. In closing out, Australian migration system in 2026 is becoming more selective, more structured, and more compliance focused. But opportunities still exist for skilled workers with strong profiles, employees with genuine shortages, and applicants who plan strategically. Employee sponsored migration isn't disappearing, it's just becoming more disciplined and more professional. If you're considering employee sponsorship as a worker or as an employer, now is the time to get accurate, up to date advice. The rules have changed, the expectations are higher, but with the right guidance, preparation, pathways to Australia and permanent residency are still very achievable. Thank you for watching. We'll see you in our next video.